Hello there, a very good evening and welcome to a brand new episode of The Role of Law. Now, the speciality of today's episode is the fact that it is important to everyone living not only in Sri Lanka but across the world, but specifically for the viewers here in Sri Lanka, because what we discuss here is mostly Sri Lankan law and the fact that we are all living in the digital age. The topic of discussion today is computer crimes. What are computer crimes, and if you are a victim of said computer crimes, what really can you do to remedy it? Where can you seek recourse? To discuss these matters and more, we've got Attorney at Law Chamila, former senior lecturer at the Thalagala Defence University Faculty of Law. A very good evening, sir, and welcome to the show.
Good evening.
So first things first, to lay out the basic framework for our viewers to really understand and grasp the depth and the scope of computer crimes. What do you mean by a computer crime?
Yep. Before going on to the issue as to identification of a computer crime, it would be beneficial for us to kind of look at the context in which this Computer Crimes Act, which specifically deals with computer crimes, was introduced in Sri Lanka. Now, if you look at laws relating to the technological field, all these laws have been a response to the challenges posed by the developments in the technology. For example, if you take copyright law was basically a response to the introduction of the printing press. And thereafter you saw certain developments in the technological field, like introduction of the photocopier, then introduction of the television, radio, then the computer, and lastly the internet, and nowadays you have these clouds as well, cloud computing and things like that. So along those lines, the copyright law developed. Now, Computer Crimes Act, or the law relating to computer crimes, is no exception in this connection. Now, with the use of computers during the 1970s and 1980s, it was identified that computers were being mainly or kind of frequently and gradually used for the commission of unwarranted and unacceptable activities. And this became a problem, and various legal systems tried to kind of address this particular problem. And the first measure which they adopted to address this particular issue was to use the existing law, basically the existing criminal law. But you see, when you use this existing criminal law to cope up with crimes relating to computers or crimes that could be committed with the use of computers, there are certain problems. Now, those problems relate to the definition of crimes. If I take an example, now take a situation where a person has taken information or data without authority from a computer. Simply said, stealing information from a computer. Now, the appropriate offense in the criminal law of Sri Lanka, which is applicable to that particular instance, would be the offense of theft, which you find in section 366 of the Penal Code. But if you take the definition of the offense of theft, it requires certain elements to be there, like movable property and in the possession of some person, and taking or moving out of that property from that particular possession, then without consent of that particular person who is in possession, and lastly the dishonest intention. But you see, when you take this concept of movable property, you can't relate it to something like data or information, because you see in Sri Lanka as well as in other countries, movable property has been defined by courts to only include tangible and visible property, property that could be touched and seen. Now, say for example, in the context of Sri Lanka, we have a specific case called Nagaya versus Jayasekar. Now, in that case, the courts held electricity cannot be the subject matter of theft because it cannot be seen or it cannot be touched.
Right.
So you can't.
So if you try and connect your power supply to someone else's so that they'll get charged, that's not theft.
Exactly. So this would kind of apply to data or information as well. So since data won't be movable property, since it's not seeable, it's not visible, and it's not tangible, right? For stealing of information, you might not be able to use the offense of theft. So this problem was there for all legal systems throughout the world. So in order to address that, different legal systems started with introducing specific legislation to deal with computer crimes
alone.
Yes, exactly. And perhaps the first legislation in that direction was introduced by the United States when they enacted this Computer Frauds and Misuse Act of 1984. And thereafter UK followed US. They enacted the Computer Misuse Act of 1990. And thereafter Singapore followed it when they enacted the Computer Misuse Act of 1993. And in India, they enacted the Information Technology Act of 2000. And here, Sri Lanka, we enacted the Computer Crimes Act in 2007. So if you take the Computer Crimes Act, it deals with the crimes from section 3 to section 40, right? Basically, it deals with hacking, that is unauthorized access to a computer or information stored in a computer. Then computer cracking, that is where you access a computer in order to commit a crime. Then you have manipulation of information which is stored in a computer, like say for example if you release a virus or something like that. Then apart from that, you have this perhaps I could construe it as an overbroad provision which is in the Computer Crimes Act, where it involves offences against national security, offences against national economy, and offences against public order. Apart from that, you get crimes relating to interception of data. Then you get dealing with information obtained illegally, and also releasing of certain information like passwords to outsiders without authority, and also dealing with illegal equipments that could be used together with a computer to commit certain crimes which are identified in the Computer Crimes Act.
Well, since many Sri Lankans are now stuck at home, especially due to the COVID-19 pandemic, they have a very close relationship with their computers and as such are exposed to the possibility of being victims of these computer crimes. Now, some of the issues that have cropped up quite a lot in recent times is the issues of privacy and also the issue of releasing of explicit content. Now, on these matters, does the Computer Crimes Act really cover these offences?
Yeah, it's very pertinent and a very good question. Computer Crimes Act, I would say, deals with the basic type of crimes which could be committed using a computer, and also certain unwarranted and unacceptable activities relating to the use of computers. But a majority of the unacceptable behaviors which you just mentioned are not covered by the Computer Crimes Act. Now, basically, you find when you say particularly the social media and the other contexts, or even with regard to the use of other things like emails and things like that, there are certain unacceptable conduct which could happen in relation to the use of such platforms. Say for example, you get hacking of email accounts, hacking of social media accounts like Facebook accounts and things like that. For that, I would say the Computer Crimes Act could be used because it talks about hacking. But there are other unacceptable conduct such as revenge pornography, intimidation, fake news, then cyberbullying, hate speech, and also these pseudo photographs. Those are where you get the
deep fakes.
Exactly, you get the image of one particular person and you mix it up with another image, right?
Say, for example, the body of one person and the face of another.
Exactly. So those might not be obscene as such, right? But it's sort of a distortion of the original image. So those things happen quite frequently. Not only in Sri Lanka, in other jurisdictions also the situation is the same. But the difference here is that in developed jurisdictions like UK, they have specific laws to deal with the conducts which we just kind of discussed. Say for example, they have this Criminal Justice Act of 2015 in the UK, and also Protection Against Harassment Act, and also the Malicious Communications Act and the Communications Act, which would deal with all the headings of misconduct which we just discussed, like revenge pornography. Now, in terms of this Criminal Justice Act, they say these sexual images which are private cannot be distributed or sent to another person without the consent of the person who's appearing in that particular image and all that. Now, as far as Sri Lanka is concerned, we don't have specific laws dealing with such conduct, but you have these old laws. For example, the Obscene Publications Ordinance,
right,
and you have certain provisions in the Penal Code as well. But I would say now Obscene Publications Ordinance has been amended a couple of times in order to make it applicable to the online context, but still there are problems as to whether how would you define an obscene kind of a publication.
Right.
Say for example, in Sri Lanka there has been a case, this was under the Penal Code, there has been a case where a person has written something which could be considered obscene on a wall of a house, and that writing could not be seen by the public. Right? That could be seen by the public, but it could not be read by the public. It was illegible for the public. The court decided that it wasn't obscene as such in such a situation. So those problems are there as far as the application of those old laws. And with regard to things like fake news and stuff, you have the provisions in the ICCPR Act, and you have section 120 of the Penal Code and things like that. But still, how it would relate to the online context, right, remains still questionable, because the law in that area hasn't developed as such. We don't have much kind of binding authority which have been kind of created by the courts as well.
So, well, it's clearly understood that there needs to be additional law, or at least reforms, much needed reforms in the area of computer crimes. But under the existing laws, since you spoke about cyberbullying specifically, if a person is the victim of cyberbullying, if he or she is being harassed on the internet, on social media, or on various other platforms, what are the remedies that are currently available under the existing system here in Sri Lanka?
Yeah, the remedies which are currently available would relate to the provisions in the Penal Code. So you get the offence of harassment, which is specified, which is particularly applicable in the context of females. So with regard to the protection of females, the concept of harassment is very broad. So that can be used, but with regard to the harassment of men, it remains a question mark. How would you define harassment? So there is no particular definition as such which is being kind of introduced.
So you mean to say a woman can be harassed but a man cannot be harassed?
It seems so when you look at the provisions of the Penal Code, because there are specific provisions which have been introduced in the Penal Code in the direction of protecting women specifically, because that is allowed by the Constitution as well under this Article 12. Say for example, you can have laws in order to kind of protect women
certain sections
and
of the
children
community.
and certain sections of the community and their interests and all that, and that won't, such laws which are there to protect women and children and other segments of the society which are specified in the constitution would not amount to discrimination. So as far as women and children are concerned, you have enough or I would say you have sufficient provisions in the penal code dealing with harassment as well as child abuse and things like that. But with regard to the men, of course, it remains a question mark whether the provisions in the penal code are effective enough in dealing with the online cyberbullying which are happening.
So if I'm being the victim, if I am the victim of cyberbullying, what can I do as a man?
Yes, basically you can take steps in terms of the penal code. You can say for example, if the act of harassment right, would fall into any of the definitions of offences in the penal code, then of course you can complain it to the police and the police ought to take action in that connection. So that is the basic step you can take in respect of such things which are happening in the online context relating to harassment and cyberbullying.
Also, another area that has come to the forefront, not just now but for quite some time, is the release of obscene photographs and videos. At times it could be an instance where a female sends it to a male in confidence and then later the relationship breaks down and these are released onto the internet and begins to spread like wildfire. So for these kind of instances, how have the I beg your pardon, the computer crimes in other countries, the computer crimes legislation in other countries dealt with these situations, and how are we dealing with it in Sri Lanka?
Yep. When you look at developed countries like the United Kingdom, they have come up with specific laws, as I mentioned earlier, with regard to dealing with the issues which you just mentioned. Now in Sri Lanka, of course, we are still using the existing law. Now, as I have told you, in the United Kingdom, the Criminal Justice Act has been very effectively used in curbing distribution or sharing of these private sexual images, and even with regard to revenge pornography, and even with regard to pseudo photographs and things like that. But whereas in Sri Lanka, still you have to use either the obscene publications ordinance or the provisions in the penal code which are there in respect of obscene publications. Now that would relate to basically sale or distribution. Say for example, if you release it to the public, you email it or if you post it on a social media platform, then distribution could be constituted, or else sometimes it might amount to public exhibition as well.
Right.
But in other situations, right, how you tackle with such conduct would remain an issue. So that is why I would think that it's high time for Sri Lanka also to have something similar in the nature to what UK has come up with, specific legislation. And also there is also this particular issue which Sri Lanka is facing, that's because we don't have a general right to privacy in Sri Lanka. Now when you look at other jurisdictions in UK, because of the influence of EU directives and things like that, they have a specific right to privacy. And in our neighboring country India also, at least from 2018 onwards, they have a right to privacy, because there is this famous decision of the Indian Supreme Court where they held that the Constitution, although I am referring to the Indian Constitution, although the Indian Constitution does not explicitly recognize the right to privacy, the right to life which has been guaranteed in terms of Article 21 of the Indian Constitution could be extended to create a general right to privacy. Now, in the context of Sri Lanka, we don't have a right to life in the constitution, but still we have decisions of the Supreme Court, at least 2 decisions. There might be more, but at least there are 2 reported decisions of the Supreme Court which have created an implied right to life.
Right.
So, it's a matter of fact and matter of interpretation, I would say, extending that implied right to life to a right to privacy. But then in that context, everything would be implied. It's like you imply on
an implication.
Right. Exactly. So, it will be kind of extending your arms too far, but I don't know how the Supreme Court would decide in the future, but it's a matter for the Supreme Court to decide.
Well, of course, we are considering drafting a new constitution.
Yep.
Many promises have been made in that regard, and of course, an inclusion to the right to privacy as a fundamental right in Sri Lanka would be a step in the right direction?
Yes, that would be, especially in the context of the developments in the technology like this introduction of the computer, internet and all those things. Now, if you look at these legislation specifically dealing with computer crimes in all the other countries, at least in the developed countries, the computer crimes legislation have come up as a package. In order to kind of address the broader spectrum, there have been other legislation dealing with privacy, dealing with data protection and things like that. Now, whereas in the context of Sri Lanka, we do have the computer crimes, but we don't have a sufficient strong law to deal with the other aspects relating to privacy, data protection and things like that.
Well, another very current issue that we're facing is fake news. Of course, at the time of the COVID-19 pandemic, even the World Health Organization recognized the fact that we're not only facing a pandemic, we're also facing an infodemic, where facts and figures are being distorted. Fake news is being shared. On this front, in Sri Lanka, we saw a number of arrests being made for the publication of fake news. Now, does this also fall under the ambit of computer crimes?
Yes. Now, if you look at the Computer Crimes Act itself, it has a very broad provision which talks about offences committed against national security, national economy and public order. And perhaps I could say that it's an overbroad provision which is not defined in terms of a particular set of guidelines or set of criteria.
Right.
So, that makes the law enforcement agencies to make use of this particular provision in the context which they prefer, and that would create some sort of vagueness in the application of that particular provision which you find in the Computer Crimes Act. Now, if you look at the Indian context, now the Indian Information Technology Act of 2000 had a provision in that particular legislation dealing with this fake news, hate speech and things like that. That particular section was section 66. But later on, somewhere in 2015, the Supreme Court of India decided that section 66 of the IT Act of 2000 was sort of vague and was sort of overbroad, and as a result of which the Indian Supreme Court, 2 judges in the Supreme Court, decided that that particular provision was clearly in violation of the Indian constitutional provision which guaranteed the freedom of information. Now, the thing is, in the Indian context, the constitution allows judicial review of legislation, but in the Sri Lankan context, because of the specific application of Article 80 sub-article 3 of the constitution, once the speaker endorses a particular bill as having been passed by the parliament, no court in Sri Lanka can question the validity of it. So, even if one could argue that the provision which we discussed, which is included in the Computer Crimes Act relating to offences against national security, national economy and public order might be in violation of the right to freedom of expression in Sri Lanka or any other provision in the constitution, the courts are incompetent to declare that particular provision as illegal or not applicable.
So we're in the final few minutes of our show, and I'd like to direct this question to you. So to bridge the gap that we have in dealing with these computer crimes that we've spoken of over the past few minutes, would the answer be to introduce more legislation, to introduce more specific legislation? What's our way forward?
One of the ways in which we could handle the situation is to introduce new legislation, but I would say that has to be done very carefully, striking a delicate balance between the rights of the people on the one hand and the interests of the society and the government. Now say for example, if you take the example of this fake news, right. Now you might consider something as fake now, but in the future it might not be fake, because if you look at the context.
And who is the judge of fake?
Now say for example, in this world there is nothing called absolute truth or absolute falsity. Now if you take the example of history, now Galileo Galilei was burnt at a stake on the basis of spreading a fake information. But later on, it was realized by the whole world that what Galileo was telling was right. And
these days, people are burnt on social media.
Yeah, perhaps you could say so. And also, if you take the example of Socrates, he was given the choice of consuming poison or leaving Athens for corrupting the minds of the youth. That was on the basis of spreading fake news or information which was not suitable. At the end of the day, he decided to drink poison rather than leave Athens, because he wanted to insist that what he was telling was right. But now we know that what is fake or what is not would depend on the context, and also depending on the context, it could differ. So when you are dealing with something like this fake news, right, you need to kind of ensure that the law which is used to control dissemination of fake news will not at the end of the day hamper the human development and the scientific development as well. Because if you look at what Karl Popper has said, Karl Popper has said the development of science is based on falsification. So that is why what Sir Isaac Newton has said was disapproved by Albert Einstein. So now in that context, if scientific development is based on falsification, controlling of false information
must be done very carefully.
Must be done very carefully. Otherwise, what you would be doing is you will be hampering the development of science and development of human progress as well.
Thank you very much, sir. Of course, that is all the time we have today on the role of law. A very interesting topic, computer crimes, and of course, one that cannot be covered in a mere 30-minute program. But of course, it is how it is. And that's an end for the Role of Law program for today. Thank you very much, sir, for taking time off your busy schedule and joining us on our show to educate the general public. And of course, also, as always, thank you very much to our viewers out there for tuning in. Until next time, take care and God bless.